Imagine you slip and fall at your favorite local charities fundraiser, and suddenly you're icing your knee wondering, can I even sue a nonprofit? It turns out the answer is way more complicated than a simple yes or no, and that's exactly where accident injury lawyers earn their paycheck. There's this old legal idea called sovereign immunity, which basically said that the king can do no wrong, so you couldn't sue the government. Nonprofits and charities borrowed a version of this shield centuries later, arguing that because they serve the public good, they shouldn't be drained dry by lawsuits. Charitable immunity was actually a huge deal in American courts for most of the 20th century, with many states fully protecting hospitals, churches, and community organizations from personal injury claims. The logic was sweet but kind of backwards, treating goodwill like a legal force field. Here's the twist, though. Most states have dramatically scaled back or completely abolished charitable immunity since the 1960s and 1970s. So, if a charity was negligent, meaning they were careless in a way that hurt you, the warm fuzzy mission statement doesn't automatically save them in court anymore. Sovereign immunity is slightly different because it specifically applies to government entities, like a city-run recreation center or a state university hosting a public event. But here's where your brain might start to hurt, because some nonprofits are so intertwined with government functions that they can actually borrow that governmental shield. Your injury lawyer's first job is basically figuring out which flavor of immunity, if any, applies to the organization that hurt you. It's like a legal scavenger hunt where the prize is knowing whether you even have a case worth filing. Some states cap the damages you can recover from a nonprofit, meaning even if you win, the payout is limited to something like $250,000 or $500,000, no matter how badly you were injured. That cap exists as a compromise, giving victims some justice while keeping charities from going bankrupt over one bad day. Here's something most people don't realize: many nonprofits carry liability insurance specifically because immunity isn't guaranteed, and your lawyer often goes after that insurance policy rather than the organization's core assets. Think of it less like suing a soup kitchen and more like making an insurance company do its job. The type of nonprofit matters enormously here, because a hospital classified as a charitable institution gets treated very differently than a professional trade association that technically files as a nonprofit. Your lawyer is essentially asking, is this organization really serving the public, or is nonprofit just a tax strategy? Religious organizations add another delicious layer of complexity, because the First Amendment sometimes protects church decisions from court scrutiny entirely. An accident injury lawyer navigating a personal injury claim against a church has to carefully separate the religious decision-making, which is protected, from the basic negligence stuff like a broken staircase, which absolutely is not. One major misunderstanding people have is assuming that because a nonprofit does good work, a judge or jury will be sympathetic and throw out the case. Actually, jurors often feel that organizations with a duty of care, like youth sports leagues or elderly care nonprofits, should be held to a higher standard of safety, not a lower one. The smart move after any injury at a nonprofit event is to document everything immediately. Take photos, get witness information, and report it formally, because immunity defenses often get stronger the less evidence you have. Your lawyer can only fight the legal battle if you've already fought the documentation battle. Here's the honest reality: the law in this area is genuinely messy and changes state by state, which is exactly why generic internet advice about "can I sue a charity" is basically useless without a real lawyer reviewing your actual situation. Accident injury attorneys who handle these cases have usually spent years mapping these specific rules in their state, and that knowledge is the difference between a dismissed case and real compensation. The good news is that most personal injury attorneys work on contingency, meaning you pay nothing unless you win, so there's no financial risk in at least having a conversation about your options. The immunity question sounds intimidating, but the right lawyer has almost certainly seen it before and knows exactly which doors are still open. If this made you curious about how an experienced team actually navigates these kinds of cases for real people, check out our links in the description to learn more about what we do.